Coffee with Beth Zedek Congregation in Toronto, Ontario, Canada. I'm Steve Warnick, Rabbi Steve Warnick, one of the rabbis here at Beth Zedek, and this has been one of the most fun programs that I've been doing, certainly, and we've been involved with this for several weeks now during this pandemic as a way to bring interesting conversation to our community over topics of the day. This morning, it is my pleasure to welcome Justice Kathryn Feldman, who is on the Court of Appeal for Ontario and now retired, but Dr. Bruce Elman, who was the Dean of the Faculty of Law at the University of Windsor from 2000 to 2011. We only have a half hour, and so our format is really more of a fireside chat. I suppose we should call it a Zoom side chat with this technology in this day and age. But as we know, and certainly those of us that are news junkies like myself, when you open the paper on any given day, one of the topics of concern is what's the impact of COVID-19 on our society, and especially the different ways in which it is impacting our legal system and our government. And so today we're just gonna kind of tread into the baby waters of these issues with these two really wonderful, thoughtful guests. We're going to talk a little bit about issues of the federal government and federalization, the relationship of the federal government of Canada with the provinces. And we'll talk also a little bit about access to justice, especially in the Court of Appeal. Let's start with the federalism and with Dr. Elman, because that's kind of like, from 10,000 feet when you're looking down, you see certainly in this country what seems to be, as you yourself said when we were talking about this earlier, it seems like the federal government and the provinces are doing this pretty well. The federal government did not invoke their emergency powers under peace, order, and good government, and the feds and the federal government and the provincial governments have basically tended to their own jurisdictions, and that cooperation seemed to work well. Dr. Elman, why don't you tell us first a little bit about what are those jurisdictions, what's been working what's been kind of working well for them?
So let me take one step back and just talk about the issue of emergencies, because I think most Canadians thought when the pandemic started that the federal government would invoke its emergency powers. The fact that it didn't, I think, came as a surprise to people. But if you think about it a little bit in hindsight, I think there are a number of reasons why they didn't, and I'll just jot them off for you, and we can explore them later if you want. First of all, health is generally a provincial issue, number one, and the provinces had already declared emergencies. In fact, many municipalities, certainly the larger ones in Canada, had declared emergencies, and therefore it wasn't really necessary for the federal government to declare an emergency. And in fact, the provincial premiers urged them not to do it. And so the federal government in the end did not declare an emergency. Second of all, the federal government had lots of power under an act called the Quarantine Act. And the Quarantine Act allowed them to, in fact, tell people they needed to self-isolate, to quarantine for 14 days when they came into the country. There are enormous powers under that act. The penalties are quite severe. An infringement could net you a fine of $750,000, 6 months in prison. If you're thought to be communicable, you could be indefinitely quarantined or held. And so the Quarantine Act gave them lots of power. Thirdly, I think the Canadians basically trust their public health people. And you can see that by the kind of celebrity status that Theresa Tam and Bonnie Henry and Dina Henshaw and these people have had throughout this time period. The fourth thing, which is we need to remember, and those of us who lived through the FLQ crisis, for example, will remember the powers that the federal government had under what was then called the War Measures Act. Well, the new Emergencies Act came in after the Charter of Rights and Freedoms, and in fact, says that the Emergency Act is subject to the Charter of Rights and Freedoms. And so it's not as kind of a powerful tool as it once was. And then lastly, of course, we have a minority government right now. And so emergencies are always harder to declare when there's a minority situation. So those are, in my view at least, the reasons why the federal government did not, in fact, invoke emergencies. To get to your question about federalism, I think that generally speaking, it hasn't been perfect, but generally speaking, the federal government and the provinces have worked extraordinarily well here. Not every decision has been correct. Probably we should have had masks on before now. Probably we should have put the travel ban in earlier than we did, but generally speaking, things have worked well. The major jurisdiction or authority over public health is provincial and municipal. And the federal government is really there to support the provinces. So that's the first element of federalism here. The second element, of course, is that all the international and interprovincial aspects are federal. And so things such as travel, who could come into the country, the airline flights, the rail, sea, whatever, all of that is federal under transportation powers, under trade and commerce, and under the control of the border. So all of those things are basically federal. The really interesting question, I think, generally that probably people have is this issue of interprovincial trade and travel. And we know that interprovincial trade, that's trade between one or more provinces, that's federal. And I think what we were sort of surprised at is the attempt by some provinces to put in travel bans. That is to check people coming into their province and turn away non-residents. And to be frank about it, I think that's constitutionally questionable. I'm not sure whether or not they could actually do that under the Charter of Rights, mobility rights, under Section 7, which guarantees liberty, and under the whole principle of federalism, because interprovincial travel is essentially federal. So these are some of the issues that that crop up under the federalism rubric in our Constitution. I will say this, if you don't mind. The one area in which cooperation has not worked, and I feel this deeply as a sometime resident of Windsor, the one area in which it has not worked is when it comes to temporary foreign workers in the agriculture.
Why is that?
Well, I mean, why it is, I think simply is that, well, first of all, I think this is a neglected, vulnerable population, those people who come to our country every year to work and send money home to their families, and primarily in Mexico, but in other countries as well. And so you've got this vulnerable population that we didn't pay much attention to before we needed them for our food supply. And I think that, the federal government brings these workers in under temporary foreign worker permits, but then the province is responsible for everything from their status, their labor status, to their health care, to WSIB, to all of these other things. And there was really no coordination. Just as of this morning, I think it is now 928 agricultural workers, 929 agricultural workers in Windsor and Essex County who have tested positive.
Help me understand a little bit about senior citizen homes, assisted living centers, and so forth, which I think also shows a little bit of shame in Canada in the sense of the way in which this population has been neglected. I think over 80% of all COVID deaths have taken place of people who've been in these facilities. And yet the Canadian Armed Forces were called in order to provide some relief. And so I just want to understand the jurisdiction here of the armed forces versus provincial government. And is this healthcare or is this something else?
Well, this is, I think most people would agree, this is a provincial jurisdiction, provincial constitutional jurisdiction entirely. Pandemics apparently exacerbate already existing problems. And we may have been able to sort of ignore these problems in the non-pandemic times. But the minute, and by the way, it's not unsimilar or dissimilar from the temporary foreign workers problem, right? They live in these kind of barracks or dorms or whatever, and the people inside LTCHs, long-term care homes and seniors homes, they also live in this kind of very, very close proximity. Cruise ships, you know, these are places where you have to be extra careful. The army, the armed forces were called in because two provincial premiers just could not see their existing complement of personnel handling the situations. They were just being overwhelmed. But that does not give the federal government, in my view at least, doesn't give the federal government any jurisdiction here whatsoever. And so I think the real issue that we have to struggle with in Canada is whether or not we want these long-term care homes to continue to be privately operated, or whether or not we require them to be all publicly operated with a higher standard, or whether or not government regulation would be enough. You know, really strict government regulation and oversight would be enough. And I think that it's not really, I don't think anybody sees this as a jurisdictional question.
Are there restructurings formally or informally that you can imagine that might be more efficient and effective to deliver services to the people? What are some of the lessons that we're learning from this pandemic that we might be, in addition to, as you said, that question about do we want long-term facilities to be public or private with better regulations and oversight and enforcement? What are some of the other restructurings that we might be considering as a result of this pandemic?
Well, I think the federal government is going to have to take more interest in how its temporary foreign workers are dealt with when they come into the country. I mean, it's not enough to simply put them in barracks or, you know, camp cabins and leave them to it. So, I mean, on that particular area, but I think that what we've learned here is, unlike after SARS was, I think, and I'm not a medical expert, I think, but SARS was an epidemic or a pandemic largely of the medical profession. They were the ones who were most at risk. And so nobody really thought about the food chain and the manufacturing chain and the natural resources and these kinds of things. And I think now we have to sort of expand this out and say, okay, how are we going to deal with emergencies more broadly, because they're not going to be confined to health emergencies.
SARS was a much slower transmission rate.
Yeah.
And so therefore, and I'm sorry?
Although deadlier.
Although deadlier. It was deadlier and faster in terms of its impact, but its transmission was slower. Right. What we have now, of course, is a highly contagious virus, right. With a profound death rate, regardless.
Yeah, no, I agree.
Justice Feldman, turning to access to our courts. Many have an assumption that justice is best accomplished in person. That you have the right to face your accuser, and so forth. The body language and demeanor matter in addition to the intricacies of debate. At a time in which public health requires physical distancing, and it's difficult, if not impossible, to be together in person, what are some of the challenges to access of justice that the Court of Appeal for Ontario is encountering, and what is it doing to try to mitigate these challenges?
So thanks, Rabbi. You've raised two extremely important issues: access to justice and public safety and safety for everyone. But before, just like Dean Elman, before I dive into what we're doing now, I'd like to go back a bit as well and talk about how the court operated before COVID. So before COVID, the court sits in panels of 3 judges. We hear appeals only. We don't hear any live witnesses. Our appeals are heard based on a record, a written record that's put in front of us. The three judges sit together for a week, hearing either civil appeals or criminal appeals. And of course, we hear them in a courtroom with lawyers usually presenting on behalf of clients, but sometimes self-represented people represent themselves and make their own submissions. So the record that I talked about is not a small thing. And for a week's worth of cases, I can tell you that if we want to take the material home to prepare, we would do it in probably 1 or 2 boxes of books that we take home with us to prepare for a week's worth of cases. So we're talking about a lot of paper. So, and I'm also that we would prepare intensely in advance. So we're very, very prepared for each case. And we hear between 10 and 15 cases per week. So that's sort of the structure. Then we come, when we're prepared and the week starts, we come in, we hear the case, then we would be in the courtroom together. Then we would, what we call retire into a room behind the court to discuss after we've heard what we're going to do. And we may deliver our decision back in court that moment, or we may reserve the decision depending upon whether it should have a written decision or whether that's not necessary in the particular case. So when COVID hit, everything had to change because, as you say, public safety required that we could no longer go into the courtroom. We couldn't have lawyers coming, the judges couldn't be there, and frankly, the staff, extremely important component of this, had to be protected. So everything had to change, and the court leadership had to figure out how to do it because we had to still provide access to justice and do it in a way that was safe for everyone. So we began, first of all, the first thing that happened is that the bar was told that they could no longer file anything in paper form in the court. The staff, we just didn't have the staff anymore to be able to handle all the paper. So everything had to be filed electronically by sort of a makeshift system that was set up to allow that. And the electronic material was then delivered to the judges electronically. So all of a sudden, from the judges working with all that paper, we're now working with documents on the screen. That was number one. Number two, no more hearings. And as you say, oral hearings is a tradition that everyone finds very, very useful, and the lawyers appreciate it and the judges appreciate it. So we had to find a way to facilitate those hearings. And of course, it was done the same way we're doing it now, through various remote hearing platforms. We've experimented with a couple of them. At the moment, we're doing Zoom hearings. So we went to Zoom hearings with electronically available documentation in a matter of weeks. And so I've had a couple of sitting weeks over this period of time. And I'll tell you one experience that I had. Before an appeal started, one of the lawyers, who was a very experienced lawyer at the bar, began by saying, before I begin my submissions, I'd like to just tell the court how much the bar appreciates the fact that you are up and running and making these hearings available. And I said to him, in turn, that the judges are very, very appreciative of the bar accommodating and turning themselves around, appearing from their offices and from their homes. Of course, the judges were at their homes too, in order to make justice happen. The staff, all kinds of accommodation has to be made for the staff, and that's being done by reducing the staff and having them work in a staggered manner because they have to always be kept apart. So we began to hear these appeals and keep everybody safe. I would say it's a very big adjustment for everyone. but everyone seems to be doing it. I noticed that Dean Elman is still using paper there for his notes, and that's fine. I mean, we all have to sort of figure our way through, and that's what we're doing.
Are any of the methods that are being used today, have you even gone to the point of thinking long term, whether or not that these methods might be used? I guess the question is that, like, thank God we have the technology to do this. God willing, God willing, there'll be a time in the not so distant future when we'll be able to safely congregate and gather again in person. But what are the, what are the perhaps the long-term the long-term impacts of some of today's technology and techniques that we're using to keep us going? Is there any thought that's been given long-term to how we might continue with some of this, because we might find that it's more effective or efficient than previous methodologies? Or are we not even thinking about that? We're just still trying to get through what's in front of us?
I think both. I think there probably is some long-term planning going on, because we have to think in the future, absolutely. But there are very immediate issues to deal with in terms of trying to possibly, whether or not we will try to move back before COVID is over, and that's being considered too, and if so, how that would be able to happen safely. But for the future, I think you've hit on something very important. I can tell you that we did have some of these platforms available before COVID, but there wasn't a big uptake on it. Everybody was comfortable the way it was. But I think now in the future, we'll be able to accommodate the fact that people don't all live in Toronto. So to have lawyers traveling from distant cities in Ontario at cost and expensive time as well, that kind of thing probably can now be accommodated. If lawyers don't want to come, they can speak from their offices, and likely we will be able to make this technology available to people who want to do that. I mean, it makes such great sense.
Also, the move away from paper, has an ecological potential impact in terms of trees and the environment and waste and recycling. That may be something that that the court might be considering long term as well.
I think that's, ecological is a very interesting point. The paper involves a lot of things. It involves a lot of staff, and it is something that people are used to, both the judges and lawyers at the bar. So I think that's something that's going to be evolving. Probably won't happen overnight, but there'll probably be a combination of paper and electronic, certainly in the near future.
I did receive a question via social media, which I will pose to both of you. And I do want to provide the caveat that certainly Justice Feldman is an active justice sitting on a bench on the Court of Appeal. And so if she's not able to reply to this question, we certainly understand that, lahatchila, as we say in Hebrew from the outset. But the question concerns access, I think, for a lower court. And the question is that there's a problem of certain litigants not having access to either the internet or anything larger than a cell phone screen for reading documents. And so the questioner wants to know if there's been any discussion about creating video conference hubs, perhaps in co-working spaces like WeWork, where the Ministry of the AG would make computer, internet, Zoom, and other backup telephone lines available to that segment of the population that cannot easily litigate remotely. I don't know if this is something that that you have any knowledge about, or if you're able to speak about because of the circumstances. But I asked the question because it came from out there. And so if either one of you wants to offer an answer or you want to decline, that's certainly fine.
Well, I mean, I don't have any knowledge of this whatsoever, and I've already been sort of outed as a paper user, but this obviously came up in universities and would come up in school contexts, and it comes up in many, many different contexts, and that is the idea that there is sort of technological inequality. Right, we don't all have the same high-speed internet. Up in the north, they don't have it. We don't all have the same kinds of hardware, the same access to software. So, I mean, I think this is something that we're going to have to struggle with in the future. I noticed, I can't remember, somebody sent me an email recently over the weekend, I think, that someone has put together a group on technological internet rights. That things are unequal, and that under Section 15 of the Charter, we ought to be talking about ensuring equality of access to technology, because it's no longer just some sort of frill you add on. It is essential to life and essential to be able to do your job. So I think this is something we're going to have to think of, just as we had to think about remaking courtrooms so that they were accessible to those who were physically challenged, and all sorts of other things that we've had to do over the years. We're going to have to think about this. That's my take on it from someone who knows nothing about technology.
I know that in the synagogue world, we face a similar issue. That you know, it's not just people that perhaps you know, are living with less resources, but also there's a lot of seniors who, you know, just find technology intimidating, try to stay away from it. And so there's you know, to ensure access to everyone has been quite the process. I know that we've taught a lot of people how to use Zoom, how to access our minyanim online. When they don't have a computer, how to use the phone, to make sure that there was a phone access that was available for people. You know, I think that certainly one of the changes that we're going to see in society writ large is going to be the access issue, now that it's very clear that this type of technology is here to stay, and is an essential part of functioning today and tomorrow.
There's a group in Thunder Bay apparently that's been working very hard to get homeless people cell phones, because without those cell phones, without some access to government resources, they just simply they're just in much more dire straits than simply their lack of housing. And it's quite a remarkable, I think it's in Thunder Bay, quite a remarkable project they're engaged in. But I think that we're going to have to think very, very seriously about access. Just as we're thinking about access to all sorts of other things, we're going to have to think about access to technological resources as well.
Any last thoughts from either of you? Mrs. Feldman?
Well, I like your thought of the day when we'll be looking back at this. You know, remember when we went through COVID-19, and that would come out on the other side of it, that's for sure. But I do think that we're not going to waste this time. Nobody's going to waste this time. We're going to learn as much as we possibly can and implement the best things that we can in order to improve access to justice and be more aware of safety as well.
I would just say that we, you know, as you said at the outset, we're just sort of skimming the surface here. There's lots of other rights issues that will come up. They'll come up in individual court actions. But obviously, Justice Feldman can't speak. They'll come up in lots of class actions as well. And I think that you're going to see some really novel arguments. For example, that I would reading one essay where the government may find itself under an obligation to take care of the vulnerable populations that we see. We see increased rates of spousal abuse. We see increased rates of child pornography and child interference going on over the internet, remarkably, like almost 100% higher during the pandemic. And so the government may be pushed to provide positive remedies to these very troublesome issues that are not the pure health issue that we're dealing with, but are sort of the outcome of the life that we've had to adopt here.
I only hope that the manner in which we continue to address these in Canada is similar to the manner in which we seem to be addressing these problems in the immediacy of the pandemic. The cooperation between the provincial and federal governments and local governments, the cooperation between attorneys with each other and with the court. I think that bodes well to this society, and it certainly bodes well to the image of a society that our Torah expects of us. In a couple of weeks, we just are starting the book of Devarim, Sefer Devarim, the book of Deuteronomy. In a couple of weeks, we'll read the parsha called Shoftim, which is all about judges and magistrates. And in that parsha is the famous injunction, really, for the Jewish people. And I think it's really an important notice for any society that's built on justice, and that is tzedek tzedek tirdof, justice justice shall you pursue. And the way in which our commentaries have historically looked on the repetition of the word tzedek, of the word justice, is that no word in the Bible is superfluous, so therefore every word has to have meaning. So the repetition of the word justice means justice by just means shall you pursue. And certainly from everything that I've experienced and listening to the two of you and watching how our government in Canada is responding to this so far, we're not perfect, we're human beings, we stumble along the way, we make mistakes and we learn. But so far the general framework seems to be very much in line with that notion. I think we have a lot to be proud of here in Canada. Justice, we want to thank you for your time and wish you well as you continue to sit on the bench. And Dr. Elman, always a pleasure to talk with you about these issues. Thank you for your career of shaping the minds of those who, many of whom may appear before Justice Feldman with an appeal.
They do.
I want to thank everyone for joining us for this edition of Conversations Over Coffee. We're continuing every week, Mondays at 12:30. We are working on confirming our lineup for the next several weeks. Please look to our website and to our social media for the announcement of who will be our guest next week and then for the following weeks after that. And for all the activities and opportunities that we're physically distant, we're still spiritually near, for all the opportunities to connect with sacred community through Beth Tzedek. By the way, our name, Beth Tzedek, House of Justice, are available to you from our website, www.beth-tzedek, T-Z-E-D-E-C. The hyphen and the C are important, .org. We look forward to seeing you again in the future. Thank you. Bye-bye.